against insolvency professionals. All professionals are having good knowledge in IBC, rules, regulations, and other acts also. Sometimes they may not adhere whatever the rules regulation defined by IBBI, or sometimes they may not adopt the code in toto. Thereby, some problems are arise. The problems is nothing but disciplinary action. The disciplinary action initiated by either insolvency professional agency or IBBI based on the facts of the case, whether it is a minor or major, like that. Accordingly, they will impose the penalty, and sometimes they will give the warning also. Thereby, it is an image risk. Image risk in the sense means if at all any disciplinary actions are initiated by the IPA or IBBI, then automatically the financial creditors, they may not interested to take the services of the IP, and therefore they will delete from the empanel list also. So we are matured person, we are professionals, we know the nuts and bolts of the IBC system, whether it is a code or rules or regulation, we have to implement in toto without any scope for giving any scope to give to the any authority. Thereby, the image will increase and we will get a number of cases to handle. In that particular scenario, today I will discuss some of the missings or errors while doing the profession, or some cases, particularly if at all the IP is missing this area, what penalty imposed. I will not mention about the names of the IP, only the names of the company and the date, etc. And this is already, this is no confidentiality, because this is, if you search, this is, these cases are also available in the IBBI, etc., etc. Now, today I will discuss a part 1, and tomorrow also I will discuss a part 2. Disciplining the IPs by IBBI, because they are the regulator, and they have to control, monitor, and they have to develop the skills of the insolvency profession. That is both the IPA, Insolvency Professional Agency, as well as IBBI. The Insolvency and Bankruptcy Code 2000 envisage the role of a professional known as insolvency profession. So the code is also defined. Your duties are like this. Your responsibilities are like this. You are accountable certain errors or omissions. All these things are defined. Not only that one, the regulations, separately the code, IP code, the regulations are also defined, and from time to time it is updating by the regulator, that is Insolvency and Bankruptcy Board of India. The role of the insolvency profession is crucial. It is a multitask. You have to handle the company. You have to follow the guidelines. You have to follow the rules, regulation, and you have to control, and the company should be as a going concern. You are answerable to the committee of creditors, and the decisions are to be taken and approved by the committee of creditors, and the adjudicating authority oversee your the activities. All these things. In addition to that, from time to time, whatever the information that is to be provided to the regulator, we have to provide. That is the compliance part is also there. At any stage, whatever the time schedule norms are there, defined by IBBI through regulation, if at all any delay is there, penalties are to be attracted. So to avoid that one, we have to follow the guidelines in toto without any dilution, The efficiency and effectiveness of the profession should be increased day by day, based on the experience gained by you. The role of the insolvency profession is crucial. His conduct may affect the interest of the various stakeholders. If you tell any I'm doing wrong things, then automatically the sufferers are none other than the stakeholders of the particular either CIRP system or the liquidation system or whatever the various products that are released by IBBA, whether it is a PPIRP or PG2CD, personal guarantor to corporate data, or the voluntary liquidation, etc., etc. He may fail to comply with the provisions of the code, rules, regulation, guidelines, orders issued therein. So once he failed to implement the rules, regulation, or code or orders, then automatically it affects the stakeholders in the IBC system. Such an important profession cannot be left non-regulated. It is regulated. That's why if at all they are not seeing and leave it like that, means the efficiency and the effectiveness will not happen. Therefore, it is necessary to have the objective, credible mechanism which does not spare any misconduct. Whatever the misconduct while doing our business, that is to be properly addressed. Otherwise, the professional ethics, professional code, all these things are wasteful exercise to the IBBA. While does not penalize the honest conduct of the insolvency. So some errors on account of workload or on account of this one may happen because error is human. So that's why to avoid that one, we have to follow the guidelines without any dilution. Otherwise, we have to pay the penalties or whatever the disciplinary committee given the judgment, we have to adhere to that judgment. IBBA exercise regulatory oversight over. IBBA is regulating IPS, insolvency professional agencies, IPS, and information utility. These three are to follow the code of conduct. Even IPS, if at all they are doing wrong things, the regulator will impose the penalties, or IPS or information utility also. IPs are also regulated by IPS, not only IBBI, but also IPS. They have to give the proper training. And once they have not adhere whatever the regulation rules and code is there, then even IPA, insolvency professional agents also, they are having the right to impose the penalties. Therefore, IBA provides a two-tier regulatory regime for IPS. One is IBBI, second one is IPA, which are regulated by the IBBI. The process of disciplining the IP by IBBA is comprised of, if you see the particular code, section 217, 218, 219, 220 of the code defines the disciplinary action to be initiated by the IBBA. IBBA grievance and complaints handling procedure regulations are also issued by the IBBA that also they will follow. So these are the two that are a process of a discipline. How the disciplinary proceedings they will process all these things are spelt out by way of the code, by way of the regulation. Now disciplinary cases against IPs. Now one by one, what are the missings that are happening in the process of CIRP or liquidation or PPIRP or personal guarantor to corporate data or voluntary requirement, the voluntary liquidation, etc., etc. I will discuss about first the weaknesses or some people they are not following the guidelines. Thereafter, one case study, and I am not mentioning the name of the IPS because that confidentiality is also it is not a confidentiality unnecessarily we should not they inform to the name of the people also. And first one, if you see the assignment without authorization, as on date of acceptance of your assignment, AFA should be valid one. Some of the IPS, they are not having the validation, the AFA. They are in the process of AFA. Simply, they are not. They are accepting the assignment. That is not correct. Whenever you are accepting any assignment that is given by the IBBI, the financial creditor or the adjudicating authority, then the valid AFA should be there. But if at all that is not there, we have to inform if at all it is in under process. Regulation 7A of the IBBI 2016 IP regulation requires IP shall not accept undertake assignment including CIRP unless holds the authorization for assignment on the date of such a acceptance or commencement of such a assignment as a case may be. That is compulsory. There is no question. No, it is in the process. In the meantime, you should not accept. On the once you are signed for acceptance letter, valid AFA should be there. The bylaws of IPS provide that if AFA is not issued, renewed, or rejected by IPA within 15 days of the date of receipt of application, the authorization shall be deemed to have been issued or renewed as the case may be. Sometimes we have applied, but there is a delay on the part of the IPA. And if at all that is 15 days crossed, they have not given the acceptance, then it is deemed to be treated that your application is accepted. Now, particularly this, therefore, however, instances of IP undertook without having an AFA and some cases without even applying for AFA in contravention of the provisions. If you apply in the process, if you mention all these things while accepting the particular case, then there is no problem. But some of the people simply accepting without renewing or without having any AFA, then it is a contravention of the code or regulations. Now, one by one issues, whatever the issues are there, I will discuss the issue later on one case, later on one issue, later on case, like that I will discuss. Names of the corporate data. In one case, not related to the AFA, it is maybe related to other issues also. In the case of a particular Lanco Infotech Limited and Sripur Power Private Limited, both are CIRP and liquidation cases dated 4/3/2024. The disciplinary committee of IBBA or IPA, they have given the verdict to the particular insolvency professional and they have imposed some penalties or punishment, etc., etc. So what is happened in that case? Whether corporate data 1 or corporate data 2, what are the issues? How this IP is violated the norms and what judgment has given by the disciplinary committee and penalty. One by one we will discuss, and one area particularly what are the missings that are happening in the process, that also simultaneously I will discuss. Contraventions. What are the contraventions in this case? Contravention with respect to CD1, corporate data 1, withdrawal of excess fees as a liquidator. So, whatever the amount that is finalized, that is to be accepted, whether it is a COC or the adjudicating authority, whatever. Some of the people, they are having they withdraw the funds from the bank account. They are having the authorization to operate the account. It doesn't mean we should not withdraw as per beyond the amount that is they accepted or approved by the committee of creditors or in the liquidation process. If failed properly calculate the fees according to the regulation when sum was not fixed the COC. If at all it is not for this one, as per the regulation, IP further acknowledge error and refund the excess amount withdraw by him to the corporate data. Corporate data's account. Corporate data means not the directors. We have to recredit that amount because he has withdrawn the amount from the corporate data's account only. The excess he should not take. Contravention with regard to Deloitte Touch, Thomas 2 and India LLP, that is DTI LLP. And if engaged DTILP, if somehow today what is happening, most of the IPs they are taking the services of IPE, insolvency the professional entities. So whenever you are engaging the professional entities, need should be there. By default, the even financial creditors are also not they accepted the services of IPS need based. Take for example, 1 month back I received a call from Bombay Union Bank of India. The particularly the CIRP cases department or stress resolution strategic business unit. The general manager asked me, Mr. Prasad, I want some clarification. So we have finalized the fees for IP, and now he is asking some amount for various other purpose. Sir, whenever you are accepting and whenever you are approval the amount that is required, that is they requested by the IP, you have to put all the terms and conditions. Then only if at all he is claimed beyond that amount, the banks are not authorized to pay. So in that case, again, even though the professional fees is there, every month he is claiming 1,50,000 for professional entity services. But the IP is also not mentioned for what purpose the IP is there. What type of services you are engaging? Because even banks are also subject to concurrent audit, risk focused internal audit, and expenditure revenue audit. All these things are there. They will also question for what purpose this IPE is there. If you are taking services, 100% they will reimburse. But at the time of the CO, you have to get the approval of the COC and then take. Otherwise, banks will not provide beyond that professional fees. So the IP engaged DTI LLP assists them during the liquidation process of the CD. However, the fees paid to them was without clear terms and conditions. Now I am paying the IP fees is finalized 3 lakhs. Now every month he is also submitting one more invoice for 2 lakhs. For what purpose 2 lakhs? Why that IPE services are required? Need you have to substantiate. If it will not substantiate, then the financial creditors normally they don't pay. Without a clear terms and condition, with varying amount over time, raising concern unjustified payments. This is the findings of the disciplinary committee of IBBA, not by me, etc. The disciplinary committee of IBBA, they have clearly defined all these things. The disciplinary committee observed that IP, while carrying his duties, engaged in the assistance of DTT LLP, was not in the nature of appointment of professional and contravened the regulations. The IBPA clearly told, categorically told, whenever you are going to take the assistance of IPA, you should give the proper information and get it approved in the COC. And simply, if at all you are claiming the financial creditor, normally they don't pay. Contravention with regard to corporate data to failure of filing avoidance application. Whatever the process laid down in the CIRP process, we have to follow meticulously. The IP failed to comply the CIRP regulation, not initiating action as required for the transaction review audit. And they did not file the necessary application before adjudicating authority. Whenever any avoidance transactions are there, you have to inform to the adjudicating authority and get it approved for request order after determination of the transaction. But without that, they are no, they are appointing in some cases, and some cases they leave it like that. The DC, the Disciplinary Committee of IBBI, highlighted that IP initial statement to the COC that the transaction audit was completed. Once it is not completed, wrong information should not be given to the committee of creditors. But in this case, what was happened? The IP has given wrong information to the particular COC. He continued to seek information from the management. Once he is continuing to get the information from the management, why he has given the wrong information to the COC? It is against the code of conduct and indicating the incomplete audit process. All these things are not the professional. It reduces the image risk of the particular IP. Moreover, he failed to inform COC about the non-furnishing information by the management to the particular transaction audit and did not take any action to seek cooperation from the management. Suppose if at all the management is not providing cooperation, that is to be informed to the adjudicating authority and the COC also. The suggestion of follow-up of information from the management further compound issue. The disciplinary committee concluded that delay over 4 months in finalizing the avoidance. What are the time schedules? Whatever the time schedules that are defined, that is to be implemented, and 4 months delay. And from the application, avoidance application from the 6th meeting till the order of liquidation not justified. So whenever the disciplinary the cases are there, the disciplinary committee, they will go through in detail. They will verify the whatever the books of records that are maintained by IP, and they will interact with the financial creditor who are the COC committee members. Then only they will take a call to take the action. In this case, on account of this wrong things, the disciplinary committee of IBBA imposed the penalty, or what penalty they have imposed? The DC, the discipline suspended the registration of IP for 2 years. Once the IP is suspended for 2 years, it is a great image risk. Again, after suspension also, whatever the black remark is there, that will continue. But even financial creditors also, this is reflected in the website also. Whatever the IBBA website, all are open system only, not a closed system. Whenever the empanelment process is happening, the financial creditors will also look into that particular the IBBA website, whether any adverse remarks are there against the IP or not, and the penalty equal to half of the amount of the professional fees to DTTIL. So the penalty also imposed return back the 50% of the amount and deposit the amount directly to the Consolidated Fund of India under the head of a penalty imposed by IBBA under that link within 45 days from the date of the order. That is a judgment given by the Disciplinary Committee of Insolvency and Bankruptcy Board of India. So they go through the total case study and they will ask the information from the IP. They will collect the information from the particularly the financial creditor or COC. Sometimes they will visit and verify the records and the registers that are maintained by IP. All these things are they will take into consideration. So we should not invite this type of things. The case highlights the IP's failure to effectively manage the CIRP process, leading to withdrawal of excess money, delays, non-compliance with the regulation. Now, what is the learning lessons in this case? The learning lessons are the findings underscore the importance of adhering the timelines. Delay. Avoidance of transaction. Whatever the timelines stipulated that are mentioned in regulation, we have to adhere. Maintaining the transparency in the stakeholders, taking a decisive action to address a non-compliance during the insolvency. So that's why the 2 years, the cancellation of the registration means it is a great image risk to the insolvency professional in that particular case. This case is particularly in this case. If you go to the case, particularly Lanco Infra Tech Limited or Shepur Power Limited, Private Limited, in these cases, the CARP liquidation, some errors are there, some omissions are there, some violations are there. That is the judgment given on 4/3/2024 by the Disciplinary Committee of IBBI. Now coming to second point, fees payable to IP. The fees payable to IP. Actually, the code of conduct IP undergo IP regulation require IP must provide service remuneration which is charged transparent manner and is a reasonable reflection of the work necessarily and properly undertaken. Some of the IPs exorbitant rates. The total amount, exposure amount is less, but a charging. In that case, how the stakeholders will get the amount? Only the sum of the IPs, almost 20% of the total value of the assets, which is not correct. So that's why IBBA is giving some regulations in this regard also. Regulation 33 of IBBI and particularly requires that applicants shall fix the expenses to be incurred on or by the IRP. Regulation 34 requires committee of creditor to fix the expenses to be incurred by the RP. And Regulation 39D requires a COC to fix the fees payable to the liquidator in the event of CD process for liquidation. The fees payable to an IP was not fixed beforehand and IP drew a fees on his own without approval for such fees from the competent authority in contravention of the provisions of the law. This is the guidelines. These guidelines we have to follow. In next second case, the disciplinary committee given some judgment, some penalty in this case. Falcon Consultancy Private Limited, that is Corporate Data 1. Global Quick Limited, Corporate Data 2. Saraswati Sales Private Limited, Corporate Data 3. Dayal Commercial Company Private Limited, Corporate Data 4. Yash Smelter, that is a Private Limited, Corporate Data 2. The judgment date is, that is the verdict given by the Disciplinary Committee of IBBA on 26/2/2024. What is the issues? What penalty that is imposed by the Disciplinary Committee? What are the issues in these 5 corporate data cases? Contraventions. What are the contraventions in this? Non-appointment of a valuer. For corporate data 1, that is a corporate data 1 means Falcon Consultancy Limited, Private Limited. That is non-appointment of valuers. If IP failed to properly appoint a registered valuer to determine the fair value of the assets of CD, in that case, IP failed. He is not appointed. He has taken lightly. He has taken casual approach. The valuation was done behest of someone else other than the authorized IP. So here, other than authorized person, someone is given the valuation, which is not correct. Also, no values are appointed and IP mislead the board about the appointment. Particularly, IBBA also he is given the wrong information. No values are appointed, but IP is mislead the board about the appointment. We have appointed like that. Once you have appointed, what is the agreement reached between IP, particularly with regard to that particular empanelment? and how many people you have invited. Out of that, why you have selected that person? All correspondence is required, and that too in the past. And if at all any fabrication is there, then they will catch hold of. Without appointing, he given wrong information to the disciplinary committee of the IBBA. Non-appointment of values in case corporate data too also similar. IP remained IRP for CD for a period of 60 days, and he did not appoint valuer, citing that he has been replaced by another IP for further proceedings. Don't wait because as long as you are there in that CARP process, on the last day also, you have to discharge your duties. No, anyhow, I am going to be replaced. Someone will come. He will look after that type of a business, not to be accepted by the IBBA because you are taking the remuneration. Accordingly, you have to follow the guidelines and non-cooperation of Shashi Agarwal in conduct of an inspection of CD3. The IP did not cooperate with the investigating authority in submitting the reports of COC meeting, mistook the stakeholders minutes report. Whenever investigation authority is visiting to your place, whatever the information, whatever the books, whatever the papers he requires, we have to provide. Delay in filing the relationship disclosure. Whenever we are appointing any professionals, whether it is a valuer or the any person for that sake, you have to, particularly the forensic auditor or transactional auditor, the relationship to be established. He is not related to me, and you have to confirm the delay in filing the relationship disclosure CD3 and a relation disclosure with respect to appointment of valuers were uploaded the website after delay of 2 months. Once you are appointed valuers, at the same time, the valuers are not related to me. That is to be uploaded. Once you have uploaded, then the problem will not arise. The complaints is also simultaneously to be happen. And a delay in filing the relationship disclosure, corporate data 4 also in the similar case, IP confirmed that RP, but the same was uploaded upon the website CD after the day of 8 months. 8 months means the total CARP process is 180 days, means that is 6 months. So, if that is verified by the disciplinary committee, definitely they will take action against the IP. Delay in appointment of valuers. The valuers appointed after inordinate delay of 84 days, violating the. Why the IBBI has given the time schedule, time norms? And if at all we are not adhered, one side the adjudicating authority, second side we are answerable to the regulator like IBBI. Prescribed time framework enumerated in the code. The DC disciplinary committee, while hearing the written and oral submission of IP and the reports of investigating authority, observed that overall conduct throughout the service rendered in causes of CDs contravened various provisions of the code. Once the investigation authority visited to your office and verified the papers, he will provide the total report to the disciplinary committee. So that's why we have to adhere. There is no other alternative. And a penalty in these 3 cases, particularly 5 cases, that is a Falcon Consultancy Private, Global Coke, and Saraswati Sales Private Limited, Dayal Commercial, Ash Smelters, all these 5 cases, the penalty finalized by after hearing, after verifying, and all these things, the committee, particularly the disciplinary committee, imposed the penalty. As a registration for IP has already been cancelled by disciplinary committee and audit data, the contraventions heard in the present case pertain to the period prior to involved several non-compliance in multiple assignments. In multiple assignments, they have already cancelled that IPS registration. Therefore, in view of the contraventions, DC imposed a penalty of 2 lakhs on IP and directed him to deposit a penalty amount directly concerned. Already his registration is cancelled. Still, the disciplinary committee imposed a 2 lakhs amount as the penalty, and that is to be deposited in consolidated fund under the head of a penalty imposed by the IBBA so and so within 45 days from the date of issue of the order. So one side cancellation, second side penalty also. So we should not invite that situation, and whatever the rules regulation we have to update. Whatever the continuous education programs are there, from time to time we have to we have to listen and we have to update our knowledge. In this case, what are the learning lessons? In conclusion, a detailed examination of IP actions reveals a pattern of non-compliance and delays in fulfilling. Whatever delay, penalty. Once it is a penalty, whatever the remuneration the IP is getting, that amount will be paid to the IBBA, and thereby he will not get any benefit on account of handling that case. His responsibility as an insolvency from the failure to appoint valuers promptly, delays in filing the relationship disclosure. Once you have appointed, whether it is a transactional auditor, oblique forensic auditor, or particularly various, only one paper, and that information also easy to comply. If at all it is not related to you, if at all any hidden agenda is there, it is very difficult to handle that type of situations. So from the failure to appoint valuers promptly to the delays in filing relationship disclosure, IP action violated the regulations and code of conduct governing the insolvency proceedings. So this is a learning lesson. These contraventions reflect a lack of diligence and attention of a procedural requirement. Once we are discharging our duty as a professional, the professional excellence is required. And if at all we are violating all the norms, all the regulations, then it is not called as a profession. Essential for smooth conducting of a CIRPs. Overall, the findings highlight the importance of a strict adherence to the regulatory framework and the timelines also. Insolvency to ensure the transparency, fairness, and the protection to the stakeholders' interest. That's why this is very, very important. Whatever the particular violation is there, non-adherence is there, not timely happened, then it is a loss to the stakeholders. That too, being a professional, knowledgeable people, we have to follow the guidelines in total or toto without any dilution. IP contravention serve the reminder for a critical need of for insolvency profession to uphold the highest standard of profession. We have to provide highest standard and a regulatory compliance in their practice. So this is a learning lesson on account of that disciplinary action that is initiated against the IP. Now coming to whatever general the errors that are happening in the CIRP system or liquidation, etc., I will discuss and followed by one case. Need not be related to that particular error. Now, cooperation. Whenever we are doing that CIRP, we have to get the cooperation from all the people, from the management, erstwhile board of directors, or from the financial creator, or the staff members, or the key managerial person, etc., etc. Otherwise, it is very difficult to complete the Herculean task, challengeable job of CARP within that time schedule. That's why cooperation is very much required. What is meant with the cooperation? A CARP requires cooperation of the CD because for the long period, particularly before handling the case, the industry or the company run by the corporate data only. He knows the nuts and bolts of the particular company. Even though we are occupying the seat of a CEO of the company, that is the interim CEO of the company for a period of 180 or extension of 90 or another extension 60, the total system known by that particular person is none other than the erstwhile directors of the corporator. It's a promote, it's a suspended directors and management. However, cooperation not may not forthcoming in all cases. Once you are occupied the seat, they will not reveal the correct information. But once that is there, immediately brought to the notice of adjudicating that. If at all delayed, the total process will be delayed. So, section 19 of the code therefore enables IRP or RP to file application to the adjudicating authority in case of non-cooperation for direction to such person comply with the instructions of IRP or RP to cooperate with them. So, that's why in most of the cases, the IPs are not filing the application with the adjudicating authority. Okay, adjudicating authority, some delays may be there, but whether we have filed or not, the disciplinary committee, they will verify. They will verify this one. And since the time essence of CARP, IRP or R must act promptitude. It is by default all the process to be completed on time scheduled and without asking anybody. IP has to instruct to the person who is providing a secretarial service, complete the task and file the application whenever without any postponement. Once you are postponed, then the total the process time will delayed. And there is instances where IRP or RP failed to file such application or filed so late that lost its purpose and effectiveness. Once it is delayed, the purpose will be defeated. On time, if at all it is completed, then good results will happen. If at all delayed, the result may get, may not get. And any delay in filing of the application, despite continuing non-cooperation, may reflect undue influence of promoters on the IP. The committee, particularly the disciplinary committee, view like that. Once it is delayed, then both are colluded. The thinking process is like that. But this is only one paper. Whatever your financial information not provided or any other non-financial the information not provided and not cooperated, prepare one or two paragraphs and file an application with the adjudicating authority. Then and there the problem will not arise in case of anything happen. So another case, the disciplinary committee has taken action against the IP. What is that case? This is a Ratnadeep Infrastructure Private Limited. This is CARP. The date of the verdict or judgment is 16/2/2024. They have given this judgment. What is that one? What is a contravention? Why IP is penalized or penalized or punishment is given? What is the reason? What he has done? Constituting COC with a related party, IP's appointment as a director in Tirupati Balaji Fibers Private Limited and Silver Tone Papers Limited during the CARP of the seed. Suppose the IP is one of the directors in company This company is a related party to that particular CARP company. You have to inform. So, where one of the substantial shares, 10% held by the directorship with the IP in the same above mentioned company constituted a violation of the code of conduct. Why you have accepted that assignment? Because the people are known to you and your stake is there. And definitely during the process, some favoritism may be happen. The independence will lost. So once the stake is there in the associate company or subsidiary, you have to decline that assignment. But for the sake of that particular, whatever the reason is there, you have accepted. But at the same time, you have to communicate it to the adjudicating authority or COC. So and so, I am the director like that. In this case, what has happened? IP further submitted that the concerns raised against him had undergone thorough examination and adjudication at various judicial levels, including Honorable NCLAT, Honorable Supreme Court, and the adjudicating, which upheld his conduct as a liquidator in accordance with the code and liquidation process. Definitely, whenever we are doing any assignment, some eyes they will audit. Some people always audit your work or your function. So if at all we are doing wrong things, definitely they will brought to the notice of the appropriate authority. If at all I am the director of the subsidiary company of a holding company, if at all I am handling that case, definitely they will tell Mr. Prasad is a director, that is a company, he is having so and so, the stake also. How is given that assignment to him? Even corporate data also they may file. So once this type of incidents are there, we have to immediately brought to the notice of a COC as well as adjudicating authority. And in the reviewing events, the disciplinary committee observed IP acceptance of directorship in company connected to insolvent entity comprised his independence as an RP. And despite the subsequent resignation from the directorship, the DC determined that a conduct raised doubts about the professional independence, even though he resigned the directorship. Later on, also, definitely some favoritism may be there. So that's why the committee, particularly the disciplinary committee, highlighted this one. They have found, they have find this information. Okay, you have resigned. Okay, well and good. But it doesn't mean that you are not going to give any favor to the company. Definitely. So, despite the subsequent resignation from the directorship, the disciplinary committee determined that his conduct raised doubt about the professional and the independence and integrity. So, what penalty imposed in this by the disciplinary committee of Insolvency and Bankruptcy Board of India? That is, DC suspended IP registration as insolvency for a duration of 3 months. Whether it is a 1 month or 10 days or 1 day also, that is a bad remark. That bad remark is reflected in the website also. Whenever the financial creditors are going to empanel, they will verify it is as good as a CIBIL report for the loans. So the bad remark should not happen. So once we are directors related parties there, we have to brought to the notice or during acceptance also mention on the letter of acceptance, I'm so-and-so director, so-and-so company, nobody will touch you. And if at all they want to give, they will give. Otherwise, they will leave it like that. They will give to another person. So the disciplinary committee, they have given this judgment. 3 months is also a great image risk to the IP. Learning lesson. What we have to learn on account of this one? Disciplinary committee found insolvency professional's appointment as a director in connected committee during the insolvency case to violation of the code of conduct. And this contravention several regulations and clauses, despite IP's argument that past legal proceeding upholding their conduct. The DC concluded that the acceptance of directorship in connected company compromised IP's independence and integrity. It's a compromise. That is not to be accepted. That is against the code of conduct of IP. That's why they have cancelled the license for 3 months. Whether 3 months or 1 month or 1 year or 2 years, particularly cancellation is a great image risk to the IP. If at all he is going to handle another case also, some people they always write a letter to the financial creditor. Sir, why you have given that assignment to him? His the registration was cancelled for 3 months. Because whenever we are doing any function, definitely lot of people will audit our moments, our activities. We should not give any scope for them. Next, errors in the CIRP. Another error is public announcement. That is a public announcement. What is the error in this regard? Section 15 of the code, read with regulation 6 of the CIRP requires IRP to make the public announcement of commencement within 3 days of his appointment. They have clearly defined. They have clearly spelled out in the regulation. Such announcement is required to be made one English and one regional language paper with wide circulation at a location, registered office and the principal office of the corporate data. That is the guidelines. The guidelines are to be implemented by the IP only. By the rules and regulation, that is to be implemented. Being a profession, you have to implement whatever the regulations are there. If at all we are not implemented in timely, that is nothing but a violation. And principal office. This enables the creditor to submit the claim to IRP and consideration such claims by the authorized stakeholder while resolving stress of the status. Not make public announcement promptly on the appointment or made it later or made it on one newspaper or made it on one English newspaper having circulation at the location of the city. This not only puts a CIRP risk but also deprives the stakeholders of their legitimate rights. So whatever the regulations are there, we have to implement without any deviation. 2 papers means one is local, the regional language means regional language. That's all. So in this case, another case I will discuss, particularly the disciplinary committee of IBBA imposed a penalty. Why they have imposed a penalty? And what is the violations that are done by the happened in this case? All these things we will discuss. Monica Electronics Private Limited, Electronics Limited. It is a liquidation case. This is also the judgment given on 16/2/2024. 16/2/2024. What is that one? What are the contraventions? What is the arguments of IP? What are the arguments of findings of the disciplinary DC, disciplinary committee or inspector's report? All this thing. The contraventions. What are the contraventions? Anomalous and non-transparent of sale of the CD. Whenever I am selling the asset of the corporate data, it should be transparent. No hidden agenda. Once it is transparent, no complaints, nothing. While selling the asset, this is the biggest area that are violated by the violation of taking place in some cases. The liquidation issued sale notice e-auction, which was adjourned twice, ultimately concluded. Why adjournment? Okay. If at all valid reason is there, you write it and file it. Later on, if at all any the disciplinary committee, sir, on account of that one only, we have deferred the e-auction. And simply you are adjourning twice and ultimately concluded means some hidden agenda may be there. If valid reason is there, even the disciplinary committee will also accept. And during e-auction process, the liquidator found 4 bids ineligible. What is the purpose? Whenever you are selling the asset, some guidelines are there. You have to verify the buyer also. And the liquidator 4 bidders are ineligible due to collusion by the liquidator. Yet filed a communicate with this one until after the auction is concluded, which is highly irregular. Additionally, the liquidator did not submit the report to the adjudicating. Once the auction is over, what type of auction you have done and how many bidders are participated and what is particularly the minimum amount and whether the amount is created or not. All these things you have to inform to the adjudicating authority. That is a primary responsibility. And regarding collusion among bidders, as required by the regulation 33(3) of the regulations, IP failure to conduct the auction process transparently, communicate updates clearly, maintain a written records of decisions was considered a contravention regulation of the code of conduct. Okay, sometimes 100%. Sometimes a differ is there. Sometimes we have to differ on account of heavy rains. No bidders are coming, or one bidder is coming. Heavy rains or floods. You write it and the paper to be filed. Later on, we may remember, we may not remember on that day what was happened. And you have to file it. The DC noted that IP communicated ineligibility of 4 applicants 1 day after the conclusion of the bidding process. Why you are told that after conclusion of bidding process, why not before? Why this disqualification based on the suspicions of collusion was deemed inappropriate? No, they are right people. But they should not participate in the bidding. He wants to give to others. That's why the ineligibility of the 4 persons. The evidence provided was insufficient. Whatever the evidence given by the IP is insufficient and a disqualification limited to competition contrary to the intention of the liquidation regulation. So whenever in the liquidation, whenever the sales are happening, transparency. That's why number of people will audit the liquidator, whether he is doing correctly or not, whether he is following the code of conduct or not. They will check up with the other IPs also, or they will go through the guidelines that are displayed in the IBBA website, whether it is a liquidation or CARP or PPIRP, whatever the products that are developed and released by Insolvency and Bankruptcy Board of India, the regulations, rules are available in the website, in the public domain. They will go through. That is simple to understand also, whatever the regulation given by them. The DC further disagreed with the narrow interpretation of a regulation. Okay, once the wrong things are there, everybody is trying to convince the disciplinary committee. They know what was happened and how he is going to convince. emphasize that the regulation aim to prevent a collusion and prompt fair competition. The DC also for differ, no, sir, for competition purpose only I am differ means where you have rejected four people, those four people are eligible people, and DC also criticized the DC also criticized the IP for disqualifying bidders without giving them the opportunity to cure the defects in their application. So whenever you are disallowing any the bidders, the reason the reason is strongly established. If at all the reason is not genuine, we should not decline their participation. IP further failed to provide evidence that disqualified bidders were duly informed before the e-auction date. So, the last date is mentioned. Before last date only, we have to inform to them, casting doubt on the transparency of the process. The DC, the disciplinary committee, questioned the benefit of limiting the auction only two bidders, suggesting more participants have led to the better maximization. Why two participants? Why not more? Once more is there, then automatically value maximization will happen. So in this case, the hidden agenda may be there. So that's why the DC has a disciplinary committee has given a punishment to the IP. What penalty they have given? Normally in these cases, definitely they will give the penalty. What penalty they have given? The penalty, DC suspended the registration of IP for a period of 2 years to run consequently from the expiry of the previous suspension order. Expiry of the previous from that the consequently the expiry of the previous one suspension order given on the expiry date to 2 years, it is much more than 2 years. So this type of errors and omissions should not arise in the CARP or liquidation or PPARP or personal guarantor to corporate, whatever the areas are there. What is the learning lessons? In this regard, the learning lessons is IP failed to promptly communicate ineligibility bidders. Whenever ineligibility is there, well in time, because well in time you have to inform, raising transparency concern. His further disqualification bidder based on the suspicion of collusion deemed unfair limited competition. IP gave no opportunity for bidders to address application issues. IP actions contravene the liquidation regulation and the code of conduct. So, particularly in the whether it is a CARP or liquidation or other areas, we have to strictly follow the guidelines issued by the IBBA. Even though our work pressure may be there or other pressures are there, the beyond that we have to follow the guidelines or regulations. Next one is updating list of claims. Updating list of claims. Whenever the paper advertisement or public announcement is given, we have to collect all the claims. We have to verify all the claims with the available books. And we have to ask if at all any shortfall is there or any omissions are there from the claimant side, we have to get. And if at all you simply reject without any valid reason, then automatically it leads to complaint. They may approach adjudicating authority. They may approach the various courts also. So we should not give any scope for them. Suppose one claim is there, he has not submitted invoice. Ask them to submit invoice. And if invoice is tallied with our company's invoice, so we have to admit that one and updating the list of claims. Section 225 to subsection 2 clause E, read with regulation 13 of the CARP, mandates that IRP or RP shall verify every claim as per the timeline and maintain list of creditors containing the names along with the amount claimed by them, the amount of their claims admitted, security interest, if any, and in respect of such claims, updated list display on the website. Once you have displayed on the website, and they will verify, and if at all any errors are there, or if at all you have accepted wrong claims also, others may comment. So we have to give the information to the public, particularly the stakeholders through website. IRPs or RP display the update CD website. So some of the IPs they are not displaying on the website, which is highly irregular, which is a contravention of the regulations. So that's why this is important to know the genuineness of the claim and the whatever any comments. Suppose I have submitted wrong claim, but by mistake the IP has admitted. Others may comment. Prasad is no interest in that particular company. He is not supplied any raw material. Why that big claim is submitted by Prasad? Why you have accepted like that? So this type of complaints will come. Okay. Now coming to the name of the corporate debtor. In another case, that is a disciplinary committee, they have taken action against IP. On which case, what is the issues? What is the penalty? What is the learning lessons? We will discuss. This is a Action Ispat Power Private Limited. Action Ispat and Power Private Limited. This is a CARP case. The judgment given on 5/2/2024. The judgment given by them is 5/2/2024. What is the issues or contraventions in this case? What are the issues and contravention? Non-conduct of a COC meeting despite several communication made by the creditor having more than 33%. Once the financial creditors, if they ask, if a minimum voting rate is 33%, then we have to accept. We have to accept. Only 1 minute, sir. Only 1 minute. Non-conduct of a COC meeting despite several communication made by the creditor more than 33% voting rights. And 59 point voting rights also 59.11 contravene the regulation of 18.3 of the CARP. Once they requested, what is the problem in conducting the meeting? The financial creditor made a proposal for making notice for short period convening from 5 days to 48 days. The provision is there. Why you are not conducting meeting? Even though 33% of the people, they asked to conduct the COC meeting, that too financial creditor, that too COC members. What is the problem? Their voting rights are also 59.11. I'm not talking about the approval is 60, different. This is 33% of the creditors, they are having 59.11. What is the problem in conducting the meeting? And okay, meeting 248, immediately they are asking, Okay, within the 42 days, you have to conduct. For immediate issues, 48 is sufficient. I need not wait up to the 5 days. However, the same could not be implemented by IRP. Why? You are the court appointed person, and you are only the facilitator. That too, whatever the decisions are approved by the COC, you have to implement. Once the COC is people is asking to conduct the meeting, why you are declining? Why you are rejected that one? However, the same could not be implemented by IRP due to pre-occupancy with the respect to the safeguarding the assets of the. Okay. Pre-occupancy with respect to safeguarding. Why you are okay? This is what the professional fees monthly they are giving some amount X or Y or Z. That is you have to discharge the total duties, not partial duties. You are preoccupied with safeguarding assets means there is no type of such events where even though you are not safeguarding the assets, some security will safeguarding the assets. Why you are rejecting? Then at the disciplinary committee, it is a not a good practice. It is against the code of conduct. And in this case, the penalty was imposed by the disciplinary committee. Took lenient view and issued warning to be careful while handling the assignments and ensuring compliance to be made with the provisions of the code and regulation. We should not invite criticism from the other people. The 33% is there. And some people, why 5 days? Why not 40 days? Why not 48 hours? Quickly, because some decisions are to be taken immediately. That too, they are not operational creditor, they are the committee of creditor members only. So, this is a lenient view issued a warning to be careful while handling the assignment, ensuring the compliance to be made with the provisions of the code. Your for the company, whatever the period is there, IRP or RP, you have to provide your services fully, not partially. No, sir, I am handling dual professions. My profession will be hampered. Means don't accept that assignment. But in this case, what he is telling, I'm to safeguard the assets. Who will safeguard? The safeguard of the assets will be done by the security. You are not always standing and keeping whether the assets are taken or care, they taken by other people or not. You are not verifying. Some security is there. So here, if you go into the depth of that particular case, all these findings are found by the disciplinary committee. Learning lessons. On account of this case, what are the learning lessons? While RP reasons for delay were acknowledged, her failure to conduct the meeting requested by the finance constitute a violation of CA. After that, she agreed. That's why they have given warning and not a penalty or not a cancellation of a registration like that, 3 months or 1 month or 1 year or 2 years like that. They have given, she is acknowledged for the delay also. Even I myself, whenever I am visiting to NCLT, the adjudicating authority is also firing. Why you are delaying? What is the reason? This is a small one. Why you are delaying? There is no answer from IPS. Then honorable adjudicating authority, if at all that situation is continued, then I will inform to IBBA like that. It's some warning also they are giving, which is not correct. Authority to COC. Authority of COC. What is the authority of the COC? The code read with the regulation specified the responsibility of IP in COC in CARP. These required decisions several matters COC with the required majority voting share. No creditor, whether secured or unsecured or irrespective of voting share or pool of the creditors, joint letter is a substitute for the COC. Some of the IPs, what they are doing, if at all one financial creditor is having more than 66%, he is always listening that financial creditor only. Financial COC means not that particular person, all members, even minority also, not majority 66%. So this is observations. Whatever I am defining here, all of the observations of the IBBA. In few cases, IP took directions creditor having significant voting power or pool of creditors. This compromised the independence of IP and amounts contravention of the provisions of the code. Committee of creditors means all. Whatever their voice are there, whether it is correct or not, whether we have to honor or not, we have to listen. No, he is 60, the 70% voting right. He is having 5%. We should not, you should not neglect that 5% people. 70% is also okay. But at the same time, we have to listen what is their views, what is their particular arguments. All these things are to be listened. In another case, the disciplinary committee given punishment to the IP. For what issues and what type of punishment? Sinway Jewels Dhanalakshmi Electrical Private Limited. This is a CIRP case. This judgment was given by the disciplinary committee of IBBA on 31/20/24. What is the issues, contraventions or issues in this case against the IP? What are the contraventions? Contravention 1 for CD1. The IP conducted auction of the assets of the liquidated despite discrepancy in the auction notice and the objections raised by the sole stakeholders. Once we have given any advertisement, auction, once or twice you have verified. If at all any discrepancy be pointed out by any person, that is to be rectified and subsequent notice are also to be given. The lack of transparency and fairness in auction process contravened the court's principles of value maximization and stakeholders engagement was also criticized by the NCLT and NCLT order because of irregularity and hasty decisions taken by the RP. Even the adjudicating authority like NCLT or NCLT also criticize. Then it is not acceptable. Contravention of corporate data 2. The IP made a delayed public announcement after CD has been undergone CIRP. What is the purpose of issued regulation for liquidation or CIRP? The time schedules are to be followed. No question of delay. Once a delay is there, it attracts penalties. It attracts the public criticism also, or the stakeholders criticism also. The announcement further contained that inconsistency in submission of guidance and lacked clarity, and therefore contravening the establishment of a regulation code. This is a second corporate data contention. But what a penalty that the disciplinary committee has given. Suspension of registration as IP for a period of 2 years. If you go through that particular case, if you read that one, the final conclusion is 2 years registration suspension. Suspension of registration for 2 years for IP. And in this case, what are the learning lessons? What is the learning lessons for us? Inconsistency in conducting auctions during Sale of corporate data are one. Assets and violation of regulation related issuance of public notice to the CD2 lead to suspension of a registration. These auctions further underscore the importance and adherence to the regulation and transparency of the insolvency proceedings. So, whenever we are doing our profession, whatever the rules, regulations, that is to be followed 100%. Even 99% is also not acceptable. But if at all errors are happening, then error is human. So if at all errors are not, they happen, and if a justification is there, definitely the IBPA will also accept, particularly the disciplinary committee. Once this type of cases are coming, they will visit to the your firm, and whatever the papers they required, you have to submit, and they will verify the resolutions passed in COC, and they will verify the advertisements. They will verify the whatever the complaints that are made by the stakeholders. All verify, then only they will take the decision. Otherwise, simply they don't give any penalty, punishment, or this one. Based on the facts of the case, based on the findings only, they will appointment of profession. In the appointment of profession, also a lot of irregularities are happening. This is pointed out by the IBBA. What are the mistakes that are happening? It is the duty of the RP to preserve and protect of the assets of the city, including continuing its business operations. Section 25, subsection 2 of the code empowers RP to appoint accountants, legal, and other profession for this purpose. Okay. If at all need based is there, you are having a right to appoint. But substantiate and file that one information in the files. If the manpower is available in the corporate data, we have to make use of those people. We should not hire. Otherwise, it is one side, the haircutting is more in the through resolution plans. And the second one, the CARP cost should be the barest minimum, not high level. The clause 23B of the code conduct under the IP regulation prohibits IP from engaging or appointing his relatives or related party. It is not a employment opportunity. You are be there for only 180 days or below 180 days or extension 90 or 60. We should not appoint relatives or related parties like that for various assignment, whether it is a valuer or forensic auditors or the transactional auditor or any secretarial complaints like that. Any of his assignment. An IP is therefore required to satisfy himself that there is a need of a service of profession such as not available with CD. Suppose for meetings, company secretary is required. If the company secretary is there in the particular company, we have to make utilize of them. Again, we should not take the services of outside people. The cost is also to be minimized. The person qualified to render professional service, the professional appointed suitable for the purpose. Some of the IPS, particularly forensic audit, in the code they have not defined the qualification and all these things. Some expert accountants, they are known to them, they are appointing, which is a contravention of the regulations. The professional is not related or related party of IP. The fees paid to the professional should be reasonable. Even though it may be the word is a forensic audit, but there is no forensic audit name in the code, only transaction audit, not by default. in a need-based approach. By default, we should not appoint the particular people. If need is there, then you have to inform to the adjudicating authority, then only get the approval, then only the transactional audit is to be appointed. That too with reasonable case, reasonable fees. He must be not be appointed any person who is not a professional. Some of the people they are doing that one. This is the findings of the IBBA, not my own. Or who is a relative or related party who is a choice of the stakeholder. He must not appoint a professional provide service to a stakeholder or professional because of the stakeholder wants to professional to be appointed. This compromises independence of the IP. And as well as the professional imposes avoidable cost on the CD. We are the CEO. We have to run the company. The liquidity problem further not arise on account of our acts and other stakeholders. Another company, the IBBA has given punishment to the IP, contravention of our regulations. What is that contravention? What type of a punishment? What is the learning lessons? This is a trading engineers international limited. This is a CARP case. The disciplinary committee of IBBA, they have given on 12/1/2024. What is that one? Contraventions. What are the findings of the disciplinary committee of IBBI about the IP? IP challenge and maintainability of the disciplinary committee proceedings and show cause notice issued against him. He challenged that the disciplinary committee has given show cause notice. They have not listened. What is my observations about that issue? He further stated that he did not share prima facie the opinion before issuing the show cause notice. Before issuing the show cause notice by the IBBA disciplinary committee, first they have to listen my views also. Also, same was filed beyond the prescribed time limit. The disciplinary committee further examined that alleged contraventions made by the IP with respect to professional misconduct, discrepancy related to the CD's status, MSME acceptance of an ineligible resolution applicant, and not communicating the same to the COC. So he is an ineligible MSME, not MSME, resolution applicant. So discrepancy related to CD's status, MSME acceptance, ineligible resolution applicant. They have fabricated today to get the Udayam certificate for MSME. It is self-registration. Anyone can enter and they will get the certificate. And whether it is satisfy the MSME definition, that is a micro, 1 crore, plant and machinery, 5 crores the turnover, and small 10 crores plant and machinery, and that is 50 crores turnover, and 50 crores plant and machinery, 250 crores turnover. That is to be defined with the latest balance sheets. Today, if at all my turnover is 500 crores and my plant and machinery is 100 crores, if at all I entered all the particulars with less, then the certificate will come. It doesn't mean that the certificate is a correct certificate. So we have to verify the certificate also. And one eligible candidate, he submitted and he allowed as a resolution applicant. Selling CD's asset without approval of the prior consent of COC. What authority we are having? Whatever our acts are there, it is subject to approval of the COC. Once the COC is given the permission, then only we have to ask. In this case, what a penalty imposed by the disciplinary committee? The disciplinary committee imposed a suspension of registration of insolvency professional for a period of 2 years. 2 years registration suspension. What is the learning lessons? The learning lessons is DC examined the challenges made by IP and found no uniformity in the whatever the show cause notice issues. If it is stated that the board empowered to consider any material regarding alleged misconduct by the service providers. So that's why this penalty was imposed. The issue of surrounding resolution eligibility, premature handling of the corporate data, prospective resolution applicant, and unauthorized sale of CD asset without COC construct underscore the serious regulatory benches by the IP, breaches by the IP. The disciplinary committee findings highlight the IP disregard for due process and regulatory compliance, undermining the integrity of the insolvency resolution process. It is the duty of the IP to uphold the principles of transparency, accountability during the insolvency. And in addition to that, 2 years, the cancellation of a registration, they given this observations also. So we will break for a tea for 10 minutes, sir. After that, we will discuss some more the cases and what are the observations of IBBA. Shall we break for tea, sir?
Yes, sir.
Okay, sir.
Okay. Thank you.
Yes, sir.
లేకపోతే కాపీ నువ్వు వచ్చిన తర్వాత ఏముంది
ఏంటి
వీడు క్యాన్సిల్ అని వచ్చింది అదే నీకు వచ్చిందా అన్న వీడిది క్యాన్సిల్ అని
క్యాన్సిల్ చేశాడా
ఇక్కడ ఏదో ఇంకో క్యాన్సిల్ వస్తే నేను చెప్తున్నాను
ఇప్పుడు ఏంటి పెట్టమంటారా
వచ్చిన తర్వాత ఇవ్వు అవి తింటా ఓ సారీ Sir, shall I start now?
Yes, sir, please.
Okay, sir. Next one is appointment of registered valuers. What are the observations of IBBA in this regard? The observations of IBBA is Regulation 27 of CARP regulation envisages estimation of a fair value and a liquidation value of assets of the corporate data. These values serve the reference of evaluation choices, including liquidation or selection choice decided by the corporate data, consequently of the stakeholders. A wrong valuation may liquidate an otherwise viable CD, which may be distress to the economy. Here, the valuation is also one important area, particularly the huge haircutting is coming, particularly whenever we are finalizing the resolution plans. Haircut. The haircut is increasing on account of, because this is a study that made by some people, because wrong valuations are also. The competency of the values are very, very important. Once they are competent, they will give the correct figures. The competency and some of the values, that is only they will get the committee, particularly the financial creditor, whatever the valuation report earlier is there, and they will take that as a base for arriving. That is not correct. On their own, they have to develop, they have to give the fair market value and the liquidation values. Given the importance of valuation, CARP regulation required fair value and liquidation of values shall be determined by two registered valuers. And it is a duty of the RP to appoint RVs only, registered valuers only. Some of the IPs, they are not taking into account of the registered values, which is a wrong this one practice. And therefore, other than RVs to conduct valuation, in some cases appointed only one registered value instead of two. That is also not correct. Two values they to be appointed. If at all the variation is high, then third valuation is required. And whatever the regulations are there, we have to follow meticulously without any deviation. But once a registered values means a registered value. This is the observations of the IBBA, not mine, not mine. In name of the company, in one issue, the disciplinary committee has imposed a penalty. And what are the issues or contraventions in that particular case? Ambience Private Limited, that is CARP, dated 5/1/2024. What are the issues or contraventions in that particular company on insolvency professional or liquidator? Failure to protect the preserve the assets of the IP, and whatever the investigation people are there, don't try to reverse and they reverse an unauthorized completion of agreement post dated CD admission into the CARP. And IP, however, submitted it was a routine transaction and has helped in improving the project completion status of CD non-publication of the public announcement on CD's website. IP did not take necessary steps, published the announcement, and on the group website of the CD did not take any reasonable measures aware himself about the existence website. He is not aware of whether the corporate data is having the website or not. All these are the findings of the disciplinary committee. Whenever they are interacting with the people, particularly the IPs, and they will find out the findings of the the disciplinary committee. He is not aware. Actually, once the claims are there, that is to be displayed in the website also. What penalty imposed in this regard by the disciplinary committee? Warrant IP to be extremely careful while handling the assignment and ensure full compliance without provisions of the code and regulation made thereunder. So here also the disciplinary committee warned that insolvency profession. What is the learning lessons? The disciplinary committee found IP to be violation of certain regulation provisions related to duty of the IP. He failed to fulfill the certain obligations, including protection and the preservation of the corporate data assets. As an IP, we have to protect the corporate data, the assets. We have to safeguard. If at all any theft and burglary are happening, then we are responsible. On the day of appointment, whatever the assets are there, whether any security is required, take the approval of the COC and appoint the security to protect the assets of the CD. If at all any the corporate data taken some assets and others are taken take away the some assets, then it is a highly irregular. Because we are the CEO of the company, that too interim CEO, that too up to 180 or extension 90 or 60, we have to safeguard the assets of the company or corporate data. However, committee took a lenient view, asked IP to be careful in this approach for future endeavors. But in this regard, the COC also hinted or warned the insolvency. That is there in the minutes also. That is there in the resolutions passed in the particular this one. Professional services. Whatever the professional services we are engaging, that also to be followed. This is also observation of the IBBI. What are the profession? An IP and every other professional he appointed independent professionals. He is not related to him, neither friends or nor relatives. They need to be paid reasonable fees commensurate with their services, and such fees must be agreed before appointment, not later on. And IP professional concerned must raise bills, invoice in his name towards such fees. Such fees must be credited to his bank account after deduction of the TDS, whatever it is there. Any payment fees to the services of an IP or any professional appointed by IP to any person other than IP or other cash be does not part of the insolvency professional cost. So, the whatever the agreed amount that is to be paid. And if at all any services are required, get the approval of a COC and for what purpose and whether that services are available in the existing company or not. All these things are to be verified. In one case, the IP is penalized by the disciplinary committee of IBBI. And what are the issues or contraventions and what punishment and what are the learnings? Steel Hypermart India Private Limited. This is the decision of a disciplinary committee of IBBI is on 2nd January 2024. What are the issues or contraventions? In this case, RP authorized a former director to represent CD and engaging advocate. RP authorized former directors to represent CD and engage advocate, which is highly irregular. IP allowed directors to represent ongoing litigation initiated by the suspended management against the debtors without seeking prior consent of COC. Consequently, board issued an show cause notice against IP for alleged violation of this duties enumerated in the code. So some of the IPs they are doing this type of errors or omissions, which is against the contravention of the regulation. IP submitted that such a step necessary for effective management on ongoing litigations, recovery of dues from the data of the CD. Okay, once the complaint is received, he will tell something, whether it is true or not, with the help of proofs, they will verify. Unauthorized delegation, violation of a statutory moratorium, and the COC approval mandates further jeopardize the assets of the city. And in this case, the disciplinary committee has penalized a suspension of a registration of IP for 1 year. And DC instructed, disciplinary committee instructed the board, the IBBA, to further notify the headquarters of Indian Bank also. The financial creditor is Indian Bank. And the majority shareholder regarding the serious violation of concerning the director of the suspended role in compromising assets without a COC approval. And for its representative being a passive onlooker on apparently serious violations. So here, the disciplinary committee not imposed a penalty on the insolvency profession, but also requested the disciplinary committee of IBBA, they requested the board to intimate to the Indian Bank about the violations. And the learning lessons, the decision underscored the importance of adherence of the regulatory guidelines and ethical standards within the insolvency framework. It also emphasizes need transparency and accountability in the management of distressed company to safeguard the interest of the creditors and state. The purpose of IP is to safeguard the assets of the company and to safeguard the stakeholders of the company, not for the some persons like remove directors, etc. The matter also brings out the complexities and challenges involved navigating the CIRP frame while balancing the interest of various stakeholders in the resolution process. The IP role is to satisfy all the stakeholders, not the director, not the financial creditor, etc., etc. Disclosure of fees and relationship. Some of the IPs, they are not intimating to the IBBA about the fees they have received from the financial creditor, the COC, on account of the CIRP or liquidation, which is a highly irregular. This is also how much fees they have received, how much amount to be paid to the IBBA, that is to be followed meticulously. This is the findings of the IBBA. What is that one? CIRP regulation require IRP or RP make a relationship and cost disclosures in the manner required by the IBBA. It is the duty of the IP to disclose the fees payable to him as well as the fees payable to the professional engaged by him while performing the duties of IP. That is a basic responsibility. They have to, they will monitor how much fees he is getting, how much fees he is paying, whether it is an exorbitant or not. Accordingly, they will take some decisions also. And once these IPs are not intimating the amount, how they will take the decision? And how they will even whatever the share of the IBBA is, that is to be paid to run the staff members, whatever the staff is there, the salaries and etc., etc. It is also duty to disclose the relationship he has been professionals engaged to him. Whatever the professionals they engaged by the IP, that is to be disclosed to ensure the transparency and enables the stakeholder to take informed decisions. Failure to disclose the details created suspicion in the minds of the stakeholders. If at all they have not mentioned, then the stakeholders, they will comment, oh, this value is relative, or this transaction auditor, he may be the friend, and that's why he is giving like this. The values are giving a low rate. There's some criticism. Unnecessarily, we are inviting. And impartiality and objectivity of IP possibility and a conflict interest he may have. In one case, particularly the disciplinary committee has imposed a penalty on IP. What are the issues? That is good share form president the Fresh Limited, Private Limited. This is CARP. That is 29/12/2023. In this case, what are the issues and contraventions? Lack of due diligence verification of claim. Whenever the claims are there, after public announcement, we have to verify claim by claim with the available records, with the computer system, or with the invoice, or with other registers that are available with the company. The alleged contravention of results around a non-verification of claims of a financial creditor during the CARP process. Non-verification and the claim accepted without scrutiny of altered the composition voting shares. If at all he is the financial, he is not a financial creditor. He may be the operational creditor. If at all he allowed, then definitely the composition of the committee of creditors may change, altered. Further, in the same manner, Honorable NCLT also noted the claim so accepted was barred in the limitation. Whenever the claims are accepted, whether limitation act is followed or not. Suppose one debt is there, that is more than 3 years. Today he is admitted the debt, but for that debt, no acknowledgement of debt. That is under section 18 of the Limitation Act. Once the acknowledgement of debt is not there for the more than 3 years debts, it is a time bar and it is not valid. Even in IBC also it is not valid. So time barred debts admitted which are not the eligible, then the composition of COC will be altered. Honorable NCLT also pointed out, you have admitted the claim of a time barred debt, which is not correct, and the reliance made with unreliable documents. IP submitted the due process of law was followed and the verification was made on the basis of document provided to him. Further asserted that the director CD did not dispute the date of a claim. Also, his attempts to obtain the legal opinion was rejected by the COC. Once COC is rejected, why he is admitted? The disciplinary committee also acknowledged NCLT findings about the reliance made upon the unreliable documents. Once you are admitting the debt, the genuineness of documents are also required. Suppose you take, for example, any debt is, suppose one operational creditor submitted, his invoices are to be verified, whether it is there in the creditors list or not. And if all these things, particularly whether goods acknowledged by the company or not in the goods received note, like that, if at all any banks are there, whatever the agreement, hypothecation agreement or mortgage agreement, whether the agreements are live or time barred, that is also to be verified. Then only we have to admit. So simply admission means the time barred documents admitted means the structure and the composition of the COC will be altered. So in this case, NCLT findings are also there. You have admitted a wrong claim. And findings about the reliance made upon the unreliable documents, which are not in the course of the business, and was viewed that IP handling the claim lacked thoroughness from the beginning, indicate the lapse of professional judgment throughout the process. Once the IP is not having that knowledge about the claims to be admitted, not to be admitted, he has to distinguish. whatever the claims are there, why the claim, whether it is available, either whether it is mentioned in the books of records of the CD or not, whether it is live or time bound, and whether it is a secured or unsecured, whether it is a financial or non-financial. If at all it is operational, it will go into operational. If at all financial creditor, whether it is a secured or unsecured. So in this case, the IP is a casual approach, not serious approach. Thereby, the penalty is imposed by the disciplinary committee. Disposed the show cause notice with warning to the IP to be more careful, vigilant while handling the assignments. That type of stinkers, that type of warnings, not advisable. Particularly, the NCLAT also pointed out he is not having the professionalism. Once he is unable to distinguish between the claims which are not eligible, then it is not correct. Learning lessons. The disciplinary committee concludes that IP handling financial creditors claim during CAIP demonstrated lack of due diligence and objectivity. While complying to a certain procedural requirement, his failure is critically assessed on the authenticity of document. All documents are to be properly verified, thoroughly verified, then only to be admitted. Later on, a lot of criticism, we are unnecessarily inviting that one, undermine the integrity and the insolvency process. Next, the IBBI findings, authorized representatives. Whether it is for class of creditors or home buyers, the process is defined in the regulation. Most of the IPs are not following the authorized representatives appointments. What are the findings of IBBA in this regard? Regulation 16A of the CARP regulation entitled Authorized Representative of Creditors in class receive a specified amount fees for every meeting of COC attend to him. Whatever the regulation that is a defined amount is there, that is to be paid, not excess. Some of the IPs they are paying more than that one, which is against the regulation. And authorized representative engaged others, whether professional or not, whether it is a class of creditor, particularly the debentures or bonds, any class of creditors are there, or home buyers, then you have to appoint only IPs, not other than IPs. Even though they are intermediary between the IRP or RP with the class of creditor, he should also be a insolvency professional, and AFA, all these things are to be verified, and any disciplinary action initiated by the IPBI or not, that is also to be verified. And the three names are to be disclosed in the public announcement, and the claimants will tick the correct person like that, whatever their choice. And such persons attend the meeting of the COC with the authorized. Once he is attended, then only the required defined pieces to be paid. Otherwise, we should not. The engagement of other persons by an authorized representative. Other than the IP, we should not allow any person. IPs only. Payment service, such other persons attend such persons. Payment of a different amount permissible under regulation. Regulation told something up to 10 to 100 some amount, 101 to 10,000, 1,000 certain amount, and more than 10,000 certain amount they have defined. Accordingly, we have to pay not a higher amount. Some IPs they are paying higher amount. So, one case, the disciplinary committee imposed a penalty on IP. What is that particular case? What are the why? What is the difference between IP and the disciplinary committee, what are the issues or what are the contraventions are there. In Golden Tobacco Limited, it is a CARP case 27/12/2023. In this case, contraventions, what are the contraventions? Incorrect classification of secured debt. If an unsecured person in the waterfall mechanism, certain place, secured person is in certain place. If at all unsecured person is categorized as a secured, then waterfall mechanism, whatever the defined is not implemented in that particular CA, the liquidation process. Incorrect classification of claims as a secured debt. The disciplinary committee noted that during CARP, the IP incorrectly classified the claims of the financial creditor Arrow Engineering Limited as a secured one. Once he is a secured one, then automatically he will be benefited. But really, he is not the secured person, he is unsecured. Despite absence of any security interest held by the claimant, he has not taken any security from the company. Why the IP is the IP in CARP process categorized that person as a secured person? And a disciplinary committee further observed that the reliance made by IP on the injunction issued by the High Court as an evidence of the security which was flawed and interpretation. Court also told the committee was view that the injunction provided by the High Court was a relief grant to the plaintiff no way constitute the creation of any security interest. The disciplinary committee also verified that the High Court order also. He is not a secured creditor. Whatever the papers are given, that is not a valid one. Therefore, the classification made by IP as a secured was deemed to be incorrect and a violation of the code. So the classification is also to be properly. In this case, the disciplinary committee imposed some the penalty. What is the penalty? The penalty is directed IP to undergo pre-educational course. Again, 50 hours. That is, it is unnecessarily a image risk to the IP. No, again you go to undergo the 50 hours. 50 hours means before registration, the insolvency professional, they have to undergo 50 hours training, then only the registration. Once this type of incidents are happening, the disciplinary committee, no, you have to attend 50 hours course, specified under regulation 5B of the IP regulation from IPA, where he is registered. Once this is mentioned in the IBBA website, then no financial creditor will ready to give the assignments to him. IP directed not to accept any new assignment under the code till successful completion of the pre-registration. So the IP should not accept. After completion of the 50 hours of training only, he has to accept. That condition also mentioned by the disciplinary committee. Also directed IP to be more careful and cautious while dealing the assignment under the code and regulation made thereunder. This type of incidents gives a lot of inconvenience and it creates image risk of the IP. So once we are handling the cases, that too IP is a profession, means professional conduct or professionalism to be implemented. What is the learning lessons? Classification of Arrow Engineering is as a secured creditor during the sale erroneous. Once he is an unsecured creditor, erroneously he has identified as a secured creditor. Despite IP's argument that the High Court injunction served evidence of security interest, the committee determined that the injunction was merely relief granted to the plaintiff, did not constitute the creation of security interest, as defined in the Insolvency and Bankruptcy Code. This case underscores the importance of accurately applying the legal definitions. Whatever the legal definitions that are given in the code, particularly the first chapter, the code definitions. Who is the financial creator? Who is the operation creator? Who is the particular class of creators? Like that, definitions are given. If that definition is not satisfied, how the IP is categorized him as a particularly the secured creditor, even though he is not eligible as a secured creditor. This underscores the importance of accurately interpreting and applying legal definitions, and within the context of insolvency proceeding to ensure fairness and adherence of the regulatory standard. That's why, as a precautionary measures, we have to go through definition part once again and correctly interpret the same in CARP or liquidation like that. The definitions are given in the chapter 1 of the IBC code. Judicial proceedings. This is another observation made by the IBPI. Judicial proceeding, whatever it is there, we have to attend. No, we are in CIRP, we don't want to attend the judicial proceedings of the courts and others. What is that one? Why the proceedings are to be attended? All these things you have to verify correctly. Then only take a call or decision. No, we are in the CIRP. We don't entertain the court cases or court judgments like that. What is that one? First of all, we have to go through that one. Section 25, subsection 2, clause B of the code mandates RP to represent the act on behalf of the CD with the third parties and exercise the right for the benefit of the CD, judicial or quasi-judicial or arbitration proceedings. You have to attend on behalf of the corporate debtor because you are the interim chief executive officer of the company. There are instances where IP failed to represent CD in judicial proceedings. No, I need not attend. Failed to represent CDs in judicial. Okay, attend because 180 days means IBC will prevail over other acts. But it doesn't mean what is that judicial proceedings? Why should I attend? What is the reasons? And RP is preserve protect the interest of the CD. If at all some cases, if at all we are not attended, then automatically the asset may lose and the CD may they lose interest on certain assets in addition to compromising the object of value maximization of the code. In one case, the disciplinary committee has given some punishment to the IP. What are the particular issues involved in that? What type of punishment? What is the learning lessons? Euro Ceramics Limited, that is corporate data 1. Shri Bhav Polywaves Private Limited, corporate data 2. Shri Bhav Polyclinics Private Limited, corporate data 2. All are CARP only, followed by liquidation. That is this disciplinary committee has given judgment on 21/12/2023. In this case, what are the contravention between the disciplinary committee and IP? CD1 issue in auction under the liquidation process for CD1. The IP has been accused of multiple auction of vehicles, including the previously sold vehicles in subsequent auction notice, causing inconvenience to the potential bidders and contravening the liquidation regulations as well as being non-transparent during the process. Once it is sold, why he has given, why he has mentioned in the auction notice? Auction is to be the auctioned. Auction notice deals with the whatever the remaining assets are there that is to be auctioned, that assets only that is to be mentioned in the advertisement. But IP has given actual multiple auctions of vehicles. Why multiple auctions are required? And including previously sold vehicles, already sold, that is transferred also in subsequent auction notice. Thereby, it is a confusion to the prospective buyers or bidders. So, this is a CD1 contention. Reduction in reserve price beyond the permissible. Normally, in Surface Act also, 10 to 15% of the fair market value they will reduce and the reserve price. If at all in the first auction this is not happened and no bidders are there, then there is a right to reduce the reserve price. But IP allegedly reduced the reserve price for a vehicle up to 33.33 as against the prescribed and the 25% limit allowed by the liquidation regulations. The particularly disciplinary committee found the service rendered by IP in violation of the code of conduct and regulation prescribed. Once in the liquidation, they defined the maximum reduction in the reserve price is only 25%. But he has 33.33, one third, which is against the contravention of the liquidation. CD 2 and 3, what their contentions? Non-circulation of minutes in the first meeting of the COC. When there is a regulation that the minutes are to be circulated to all the people, particularly the COC members, within 48 hours. If IP delayed the sharing of minutes meeting both CD despite the 48 hours time framework prescribed for which entering transparency and a timely action. Non-performance of various activities in CIRP. Some of the whatever the CIRP process timelines are there, some timelines not adhered, some aspects are also not taken into consideration. If failed to perform various activities mandated during the CIRP, such as appointing of valuers, determining the avoidance and issuing the resolution plan, and IP failed in these areas, non-performance jeopardizes is the term-bound nature of the CIRP. So in CD 2 and 3, these are the lacuna or the mistakes that are committed by the insolvency professional and the control and custody of the corporator. Once you are taken charge as a IP of the particular company, IRP as a particular company for CIRP process or liquidation, you have to take into custody of the assets of the company. What are the various assets? Whether it is secured, secured means security available or not. And if no security is available, immediately you have to appoint the security. Then the assets are to be protected, even against the natural calamities like rain or whatever it is there. IP did not take appropriate control of CD's assets as evidence and suspended management involved in managing affairs. Once he is reported, suspended management should not handle the company, which violated the duty of preserve and protect the CD assets. Withdrawal of the amount of CIRP without COC approval in the matter of CD. Bank account, the power to operate may be there. It doesn't mean that your fees without approval, you should not withdraw. But in this case, what was happened? The IP withdraw his fees without approval of the COC. IP withdraw the funds from CD's account in lieu of a CIRP cost without COC approval, violating the regulation require expensive ratification by COC. What penalty? Normally, penalty will be higher. Suspension of registration for 2 years. So, if that is the case, gross negligence, gross violation, not minor, gross misconduct. So, here, what is the learning lesson? IP handling the CIRP reflection serious violation. Regulatory requirement, lack of adherence of the prescribed timelines and the procedural obligation. The disciplinary committee viewed that he is violating the norms and procedural obligations or requirements. The contravention undermine the efficiency and effectiveness. The CIRP is not effective and efficient. Once he is violating, the CIRP quality will be damaged of the CIRP process, potentially compromising the interest of the stakeholders involved. And IP's action highlight the importance of upholding the regulatory standards. Whatever the regulator is given standards, that is to be implemented by the IP. If at all he is not implemented, for what purpose the COC or financial creditor or adjudicating authority appointed him and conducting insolvency with integrity and transparency. That is required. And transparency, integrity. If at all he is withdrawing his fees without any approval, and the CIRP costs also without any approval, he is withdrawing means it is a highly irregular and gross negligence. Related party transaction. What is a related party transaction? This is observations made by the IBBI. The related party that is not to be allowed, whether it is in COC meetings or in financial creditor also, financial creditors also. If related parties are there, they are not the part of the COC. Only COC is unrelated financial creditors. Even the financial creditor is there, he is a related party means he is not the member of the COC. But some IPs, they are the creation of COC with a related party, which is highly irregular. This is an observation of the IBBI. Section 28 of the code requires RP to make a prior approval of the COC before undertaking related party transaction during CIRP. Such any transaction without approval of the COC is void. Whatever the decisions taken by them is void if a related party is there in the COC. This puts a transaction risk and compromises objective of value maximization CIRP and may reflect intention of the RP to give undue advantages to the related parties. This is an observation made by the IBBI. And the name of the corporate debtor. In this case, particularly, the disciplinary committee imposes some penalty to the IP for contravention. That is a Horizon Concept Private Limited, that is corporate debtor 1, and Vardhaman Build Tech Private Limited, corporate debtor 2, both are under CIRP, that is dated 8/12/2023. In this case, what is the violations that are made by the IP? And what type of a punishment or penalty that is imposed by the committee, disciplinary committee? What is the learning lessons? Contraventions. IP failed to respond multiple request information sought to investigating authority during CIRP, both the corporate debtors. Once investigating authority IA is asking, investigating authority is none other than either IPA investigating authority or IBBI investigating authority. If they ask some information that is the provided to be provided by the IP, that is a basic responsibility of IP, because the regulator is asking some information that is to be provided by IP. He also failed to submit mandatory forms required by regulation and caused further hindrance of investigation process. Whatever the forms that are there, that is to be uploaded by that is to be provided by the IP. That is not provided. Once it is not provided, how the investigating authority will get that information? Okay, some information for investigating authority available in IBBA website. But IP is not uploaded that forms are required forms, either CIRP process or liquidation. Third one is a non-conduct of CIRP proceedings for CD. IP failed to make take any significant step toward conducting of CIRP after initial public announcement. Once the public announcement is given, he is putting efforts to start the frame the COC members and start the CIRP process. But he has not taken any action about the CIRP process. He did not consult COC, responded to Kratos claims, or holding COC meeting. No action. Whether he is having a knowledge about CIRP or not, then the disciplinary committee viewed seriously. Delay in filing of a Form E for CD2, IP submitted from an annual professional fees report. That is also not provided. For CD, 7 months past the deadline, hence violating the regulation and code of conduct. Once 7 months completed from the date of due is not provided means Form E, whether it is a zero or not received any amount, he has to submit. Then a penalty. Registration of IP cancelled by the disciplinary. He is not fit or not suitable for insolvency profession. Not 1 year or 2 years or 3 months. Permanently debarred. He is not fit person to act as a IP. He is not conducting CIRP. He is not conducting verifying the claims and admit the claims. Nothing is there. That's why they permanently removed from the IBBA register and IPA register also. Learning lessons. IP not done his duty diligently while conducting CIRP process of the CD, non-filing of the forms, violating the timelines and non-cooperation with the investigating authority, demonstrate IP disregard the regulatory obligation, lack of diligence in performing the duties of it. Once he got some assignment, it means he has to do or inform. If at all he don't want to continue, inform to the concerned authority and discharge. The other person will be appointed by the concerned authorities, whether it is a adjudicating authority or the financial creditor. But if at all you keep quiet, what is the purpose and fun in appointing as an IRP or RP? And in one case, the CD, particularly the DC, disciplinary authority imposes some penalty. And what type of the contraventions or issues involved? JSM Devacons India Private Limited, that is corporate data 1. New Tech India Limited, corporate data 2, both are under CIRP. The date is 2011-2023. The disciplinary committee order dated 2011-2023. What are the contraventions? The common contraventions with regard to CD1 and CD2 common. Non-cooperation of investing authority IP failed to respond to the notice sent to him by the investigating. Investigating authority means either from IBBA or IPA. If they are asking some information, if IP is a non-cooperative, then it is highly irregular. While investigating both CDs, not only notice sent by the different investigating authority, but subsequent reports sent them are also not reciprocated by him. No response. No response from him. Whether he is the investigating authority or else. He don't bother about the investigating authority, which are from the IBBA or IPA. Then they will take a serious call about the IP. An IP is a duty to assist a cooperative with investigations, and not doing so has violated the regulation of the code of conduct. Once he is not doing, he is violating the code of conduct. And common contravention with both failure to submit CARP forms, IP failure to submit the CA forms within the stipulated delay ranging to 71 days. No forms in time, all are delayed, and the 71 days. IP submitted the technical glitches caused a delay, which was not accepted by the disciplinary committee. Whatever the reasons he has given, that is not substantial and deemed to unconvincing excessive. Delay in submitting the disclosure, IP delayed the submitting the relationship and cost disclosure of the CDs. Timely disclosure are crucial for transparency and accountability of the insolvency. That's why the DC, that is a disciplinary committee, taken an action against the IP. Contravention with regard to the respective CD1, delay in conducting a first COC meeting within the stipulated timelines. He has not conducted COC within the time stipulated. That is also delayed. Shorter notice period for second COC meeting, only 3 days, violating the minimum 5 days. One in case of urgency, only 48 hours. But normally we have to give the 5. But he has given only 3 days. Non-appearance before the adjudicating authority. Once you are the IP, you have to attend the case on regular, whenever the case is date is there, you have to attend for the case and you have to hear either physically or online and you have to apprise your information to the adjudicating authority. Non-appearance before adjudicating authority and use contemporaneous language in his submission. Whenever there is the informing to the adjudicating authority and in a convincing manner, it is facts and figures and all these things. Contemporaneous, that is language, is used. Non-conduct of a CARP over 2 years after 6th COC meeting. What is the purpose of the 180 or 90 or 60? That is only 2 years after 6th COC meeting and CARP, that is completely delayed. And after 6th CIRP, the COC meeting, after 2 years only, the 7th COC meeting was initiated. Non-cooperation handling the assets of new RP despite instruction from adjudicating authority, embezzlement of earnest money deposit. So non-cooperation handling over. Once the new RP was identified, he has to hand over all the papers to the new IP. Some of the people, they are not cooperating in this area. That is also serious. Once the case is given to other person, whatever the files are there, whatever the information is, well, discuss that one and handing over. Then take the acknowledgement and inform to the adjudicating the ABBA accordingly and adjudicating authority accordingly. Thereafter, nobody will pinpoint that earlier IP. Otherwise, problems will arise. And what penalties happened in this case? That is, the disciplinary committee is registration of IP completely cancelled. No, for 3 months or 1 year or 2 years, completely he is not fit to act as a insolvency profession. That is the decision making decision taken by the disciplinary committee. What is the learning lessons in this regard? IP's habitual non-cooperation with authorities, lack of a profession. While functioning, IP demonstrates disregard for regulatory obligation and a lack of diligence in performing the duties as an IP. After 6th COC meeting, after lapse of 2 years, he conducted 7th COC meeting, means it is a gross violation of the regulations that are defined by the IBBI. In other case, the IP is penalized by the disciplinary committee. That is a GTHS Retail Private Limited. dated 1/11/2023. What is the contraventions? Failure to protect the preserves of the assets of the city. That is a basic responsibility. That assets are to be preserved by you only. You are the interim CEO of the company. And simply not coming to the office and leaving the office by way of that is not the criteria. How many staff are there, what type of production, whether production function or HR function or marketing function or finance function or administrative function, all people are working correctly or not. Day-to-day business you have to handle with the help of supporting staff, with the help of supporting functionaries. And you have to safeguard the assets of the corporate data. IP did not take any action, recover security deposits and work in progress, which lead to significant decrease in the asset value. Once partial amounts are there, or security deposits are to be get back from the contracts, or work in progress amounts that bills are to be submitted, you have to do with the help of the supporting staff, either finance department or other department. Decrease indicating the approach IP through the CARP. He has taken that CARP process lightly. IP further allowed suspend the director to operate CD's bank account. Who is he? The corporate data, once IP reported, first and foremost, the IP has to go to the bank and change that the particular account, and he has to give provide that order of NCLT that the handling of the power to operate the account is IP only, not the earlier directors. But even after CARP also, the CD's bank account suspended director operating means it is gross negligence on the part of the IP. Lead to unauthorized withdrawing, show causing IP failure to preserve and protect the assets of the city. Once you have given the chabi to that suspended director, he will use the funds as per his wishes and delay submission of CARP forms. IP has submitted CARP forms to the board with a significant delay in violating the times stipulations enumerated in the code. Some of the IPs, the fear psychosis is there. If at all I have signed on the check, later on whether I am liable to for that amount or not. So that's why he is given the power to operate the account by the suspended director instead of by him. He further submitted that delay was caused due to operation issue while filing misunderstanding regarding the applicability of some forms. Some reason they are giving, which is not a valid reason. The disciplinary committee upheld the contravention on account of IP failure to submit them within the time. And what penalty they have imposed? Suspension registration for a period of 2 years. The disciplinary committee suspended that particular IP for a period of 2 years. That is enough. Definitely after 2 years, definitely he will not get any cases. Or empanelment also, the particularly the banks are also, they are also continuously verifying the IBPI website. While finalizing the empaneled IPs, they are verifying the websites also. Learning lessons. The decision reflects the seriousness of the charges against IP and breaches in service provider related to the asset preservation of and CARP form submission suggests due compliance and oversight during the proceedings. So that's why whenever we are accepting that a particular assignment, we have to complete the assignment in a proper manner, not an irregular manner, by following the rules and regulation and the code of the particular IBC 2016. In another case, the particularly the disciplinary committee, imposed some penalty on account of a contravention. What is that case and what are the contraventions, etc.? GTH Retail Private Limited. This is a CARP that is dated 31/10/2023. In this case, what are the contravention? Lack of effort in realization of assets of the city. You have to do get the better price, maximum price, not a lower price like that. Adjudicating authority observed that a significant gap between the liquidation value and realized value. Liquidation value, normally it is less than the fair market value. Even the realized value is less than the liquidation value. And thereby, the sufferers are ultimately the various stakeholders of the company through liquidation of the asset. Take for example, 4 crores 28 lakhs 98,000, a maker amount of 13 lakhs 32,042. Where is the 4 lakhs 28? Where is the 13 lakhs 32,000? The wide difference. The alleged contravention shows that lack of effort in realizing the asset. Simply selling. If at all 4 lakhs 28, the 4 crores 28 lakhs property, if at all anybody is giving for 13.32 lakhs, everybody is ready to purchase. This has happened in the case of GTH Retail Private Limited. And IP further submission highlighting complexities of the business structure. No, sir. This is this company. That is the amount. It is an. We will not get more amount like that. And some reasons. If at all he is doing wrong, then always he will substantiate. No, sir. Account of the business structure challenges, that too COVID pandemic 19. That's why I'm realized this much amount only. This is also great thing like that. He is informing, but disciplinary committee they don't agree. While hearing the case hand, the DC scrutinized the communication made between IP and suspended directors, indicating lack of cooperation from the latter, providing the necessary document and information related to the debtors and creditors. Once disciplinary cases are there, the disciplinary committee they will go in depth and find out whose fault is this, whether it is a IP fault or others fault. And we should not give a scope for them. We have to follow. We have to follow. Where is the 4 crores and odd, and where is this amount that is 13 lakhs? 4 crores 28 lakhs and 13 lakhs 32,000. Why the difference is there? But he is telling it is a challenging, it is a difficult to realize, and pandemic, all these things. He will not get any cooperation from the erstwhile directors. Disciplinary committee also noted IP efforts and challenges faced due to uncooperative stance, suggested that he could not sort directions from the adjudicating obtain the information. Once there is no cooperation from the adjudicator, from the management, erstwhile management, then he has to brought to the notice of the adjudicating authority. There is no correspondence in this regard. That's why the DC is taken initiation to give penalty for him. What penalty? Cautioned IP to be more careful and vigilant while handling the assignment. This type of cases, the IP has given warning or like that. And learning. A summary of the finding highlight the complexities and challenges by the Rastogi in realizing the assets of the city. That remit Rastogi is the insolvency profession, underscoring the need for cooperation and clear guidelines from the relevant stakeholders fulfill the duties of the liquidator. And in the next case, particularly the disciplinary committee, Lifestyles Fitness Private Limited. It is a liquidation case. The order issued by the Disciplinary Committee on 9th October 2023. What is the contraventions? Rejecting the claim of operational criteria. The rejection of the operational criteria claim by IP was based on the absence of invoice price supporting the debt claim. Once we are rejecting the claim, simple, flimsy grounds we should not reject. Some of the invoices are, the duplicate invoices are available, or the invoices are available with the company also. If at all he is unable to provide, the second set is available with the company also. Despite adjudicating that the previous determination of the debt existing, IP rejected the claim twice, contravening the code and CARP. Actually, he determined, despite the adjudicating that the previous determination of debt existence, he informed earlier these are the claims, and today he is rejecting that claim. IP argued that the adjudicating authority only confirmed the existence of debt, not its quantum. He is arguing in a different manner, which required further substantiation. He highlighted the lack of clarity on the amount of the claim and the summary nature of the proceeding before adjudicating authority. He further emphasized his efforts to seek documentation from operational criteria but received no adequate response. But whenever we are rejecting any claims, we should be more cautious. Okay, sometimes the operational criteria may not provide the information that is required by the the IP or IRP. Whatever the transaction is there, the replica or that transaction documents are also available with the company. Whether it is a debtor or the creditor or whatever it is there. So we have to verify the records, because in the finance department, all are properly filed. Simply without verifying all these things, if at all we rejected the claim, later on the consequences are to be faced by us only. IP no acceptance of OC claim was based on the importance of submitting entitlement with the supporting proof as mandated by the regulation. The disciplinary committee observed adjudicating authority had previously admitted the CD into CARP based on the OC's established date. Once OC has filed an application for CARP process, that too the adjudicating authority verified that one and admitted the case. And later on confirmed by NCLAT. What is the problem in admitting that claim by the IP? Therefore, adjudicating authority overturned the rejection of the claims of so-and-so, directed its admission. Thereby, IP has been warned to be more carefully and vigilant in complying the directions issued by the adjudicating authority in existing as well as a future assignment. If the adjudicating authority warned like that, it is an image risk to the insolvency profession. The apex authority, that is adjudicating authority, warnings not to be taken as simple. So this in this case, even though adjudicating authority told you please admit means the court directions. Once you are disobey the court directions, then it is a gross negligence on the part of the insolvency professional. Learning lessons. In conclusion, the case regarding the rejection of operational criteria claim, IP present the complex scenario of involving a legal interpretation, procedural compliance, and adjective actions. Despite the initial rejection based on the absence of supporting invoice, subsequent reviews highlighted the discrepancy in the interpretation of the regulation and the adherence of the court directives. Who have to oblige the court directives. Once the case is admitted by the court, After thorough verification, only they have admitted. And once it is not filed, once the court is admitted, and the court is also instructed the IP to admit that a claim means we have to obey the directions of the honorable adjudicating authority. The analysis underscores the importance of a meticulous adherence to legal directives and procedural guidelines in insolvency proceedings. And the IP action, while possibly stemming the desire to ensure that due diligence, were deemed inconsistent with the rulings of the competent authority and the regulatory framework. In another case, Mr. Vaibhav Singhal, personal guarantor of a so-and-so company, Vishuman Sarup Ram Kishan Agro Private Limited, that is 6/10/2023. And here also, the adjudicating authority given some penalty or punishment to the IP. What are the contraventions? Non-filing report of insolvency resolution process in case of Karur Vaisya Bank filed for insolvency against the personal guarantor to corporate data, where IP was appointed the resolution profession by the NCLT. Non-filing the report of insolvency resolution in case of. Further, it came to attention that disciplinary committee that IP has requested for replacement of RP, citing his health issues, which was the reason inability to fulfill the duties promptly. The DC found IP is a delayed awareness, both appointment but not noted insufficient efforts to secure replacement. Whenever the IP is not interested to take over that particular assignment, he has to inform to the appropriate authority. In the meantime, the process should not be interrupted, and he has to put some efforts, extra efforts also. What is the penalty? IP has been warned to be more careful, proactive in handling the assignment in the existing as well as future endeavors. Because here the personal guarantor to corporate data not that much serious. That's why the court has given this direction. Learning lessons. The present case importance of due diligence and prompt action in insolvency and bankruptcy. While IP explained his health issue caused for his delay, the disciplinary committee emphasized the need of insolvency to uphold their responsibility diligently. So they should not dilute once your health conditions are not up to the mark. And whatever gratuity is there with the help of or inform to the financial creditor about this issue and ask them to replace at the appropriate. Through leniency was shown due to health concerns, IP was cautioned to be more proactive in handling the assignment under the insolvency in future. Next one is Innovative Technology Private Limited. This is CARP case. That what punishment that is given by the, what is the contravention? Background of the case, particularly the disciplinary committee previously issued an order suspending the registration of IP for 3 years. However, Honorable Bombay High Court directed DC to conduct a fresh hearing and pass a new order. Therefore, in compliance with the above mentioned direction, the case against IP was heard again. So, DC was given order for suspension for 3 years, registration cancelled. But Bombay High Court has given to fresh hearing. Non-cooperation of the particular the verification failed to provide crucial documents requested by the investigation authority. For instance, once the IP is not cooperating, not given any support to the investigation authority, that is point one. Delay in making public announcement by the IP delayed by 33 days, which is highly irregular. And DC took note of delay, which was caused due to delay in receipt of the order from NCLT registry, which is found acceptable based on the circumstances. Control and custody of asset of a CD. IP failed to take immediate custody asset of the CD, and the forensic audit report and the COC meetings minutes indicated that awareness certain assets, but failed to appoint appropriate control. Once this lacuna is there, this problem is there, definitely the DC's action is correct. And that's why the High Court also again hearing non-appointment of registered values within the stipulated time. That is one point raised by the disciplinary committee. Inconsistence of insolvency commencement date and filing of document regarding violation of CARP timelines. IP failed an application existing CARP period within the mandated time. All these things are there. So once this type of errors are there, the action taken by the disciplinary committee is correct. Disciplinary committee is correct. So that's why the court again hearing means again they will go through all these things and accordingly they will inform to the High Court also. Non-compliance of regulations, non-maintenance of list of creditors, non-filing of application, all are the irregularities. But he approached the High Court. High Court again asked the disciplinary committee to fresh hearing. Even in the fresh hearing also, the same will be repeated. He neglected the form opinion of a transaction potential under section so and so of transaction, and he did not submit any requisite application before the adjudicating authority. Then what is the penalty? Suspension of registration for a period of 2 years. Finally, even though High Court told, again they will put forth whatever the lacuna, whatever the issues that are involved in the earlier decision, and they will reiterate and submit to the court, and they have taken they have suspended him for registration for a period of 2 years. Learning lesson. Disciplinary committee found IPs conducted during insolvency highly unsatisfactory and unprofessional. He displayed aggression and useful disreputable language during the hearings. That is not correct. Even though in the court also, we should be follow the professionalism. Challenging the authority of the disciplinary committee means the highest authority of IBBI, the regulator, and the directors from the High Court of Bombay. And Mr. Sarkar demonstrated contempt in the monitoring the activities of the board and evaded his responsibilities on the code and regulation. He failed to prioritize the time resolution, disregarded the procedural complaints, and neglected seek an unnecessary adjudicating with delays, and all these things are there. That's why whatever the decision taken by the disciplinary committee is correct. Moreover, Sarkar's failure to address the suspicious transaction adhered to the mandated timelines underscored the discord for this one. DC concluded that the action warranted 3 years of suspension considering the severity of the contraventions. Once the severity of the contraventions are there, they are right. They are right. Once they are giving punishment, they will highlight all the irregularities with the proofs also. Simply, the disciplinary committee will not give any judgment in the light of the elapsed time suspension. DC invoked the powers of suspended IP, effectively holding him accountable for failures to uphold the provisions of the code and regulation. The last one is the name of the corporate data. Blue Plast Industries Limited, CD1. Anil Printers Limited, CD2. Today's Writing Instrument Limited, CD3. Wings Travel Management Private Limited, CD4. All are under liquidation. That the decision was given by the disciplinary committee on 5th September 2023. What are their findings, contraventions? Fees of IP charged excess for CD 1, 2, 3 amounting to 17 lakhs 60,000. The board pointed out incorrect percentage applied. IP admitted overcharging. IP also admitted. He later refunded the excess amount to the board. Okay. IP argued that the charged fees based on a genuine presumption that the first 6 months and board guidance lacked clarity. He is argued further admitting the error, refund excess promptly after the board notice and expresses his commitment complying the regulation in future. He is fully agreed. Whatever the excess charge is, he is refunded, and whatever the ambiguity is there in the instructions of IBBA, he is pointed out. What penalty? DC imposed a penalty of 1 lakh to be deposited within 45 days. Issuance of the order further warranted IP to be more carefully, strictly complying the provision. Once he is refunded the excess amount, definitely the disciplinary committee will also take into consideration about his wrong things, and he is accepted the mistake also, and some ambiguity is there in the instructions, that also he highlighted, that DC also admitted that one only 1 lakh they have learning lessons. Several discrepancies highlighted regarding the charges of excess fees. IP in response acknowledged the errors. Once the mistake was happened, if that is accepted or acknowledged by the IP, then the penalty or whatever the punishment that will reduce. And a notification by the board, the DC found the interpretation of IP regulation flawed, indicating lack of understanding of the code and regulation. Okay, they also agreed that interpretation wrongly understand. That's why they have reduced the particular amount like that. Particular amount like that. This decision particularly underscores importance of meticulous compliance with the regulation governing insolvency and reinforce the professionals, highlight the standards of the professional conduct. To conclude, on perusal of the orders passed by IBBI, it has been observed that it has considered the fact that insolvency regime in India is in its emerging phase, and the profession of insolvency is also nascent stage. Therefore, low impact and indeliberate violations of law generally excused by the regulatory authorities by merely imposing some penalty in most of the cases. They are not, they will listen. If at all that a person is doing on account of some small irregularity and unknown, or he is not understanding the proper guidelines, then they don't give any major punishments, and they will small punishment, and in one case they have given only 1 month this one. In another case they have given the 50 hours again they has to complete. So small mistakes and if at all it is not intentional, they will take lightly, and they will give some caution message to the IP. Anyhow, we have to follow the guidelines in toto without diluting. And whatever the IBBA observations are there, I have given the IBBA observations. That observations are very, very crucial, and we should not violate that one. And this type of disciplinary cases, if you go through that one, then whenever we are discharging our duties in liquidation of CARP, it will be click in our mind, and definitely some good result will be there, and we will not repeat that type of errors or irregularities. So this is in brief. However, if certain actions are taken by IPs purposefully and affects the profession, maximization of a value of the corporate data violates the entire purpose of IB, the disciplinary took a serious action. Small things they will leave, and they will give with a small the caution message, but intentionally, purposefully means definitely they will impose some penalty. It is clearly evident that IBBA AP emphasis on self-discipline We should not go to that IBBA. Our cases should not go to the IBBA. Self-discipline is very, very important. By reading the regulation, by reading the code once or twice, and every function which an IP required to perform as per IBC highest level of professional competence. This is not a big act. This is not a rocket science. This is a simple science. It is very easy for us to complete this task or this CIRP process easily, subject to following the regulations, code, and rules. Financial value maximization. Therefore, IP is expected to comply the provisions on law, ensure the utmost integrity, objectivity, independence, and impartiality. That is required. Okay, today for small amount, if any wrong things are happening, then great loss to the IP profession. So we have to build up our image, and the build-up of the image is nothing but following the rules and regulation and code. This is in brief about the today's one, sir. Tomorrow also I will discuss some more case studies, particularly on CIRP, etc. The basic objective is to improve the efficiency and to zeroize the errors and omissions. Zeroize, not minimize. Zeroize them. If at all any errors unintentionally committed by the IP, the disciplined authority, they will verify the total case once again and hearing and verifying the papers, and they will give the caution, and purposefully intentionally means it is dangerous, and they will impose the penalty with monetary as well as a suspension of the registration, etc. So thank you very much, sir, for hearing this, particularly 2 hours, whatever 3 hours are there. And thank you very much. And this PPT also I'm sending to all the people. I'm sharing to the madam. Madam will in turn, she will circulate it to all the members. Thank you very much and good night to all, sir.
Thank you,
Madam.
sir. Thank you.
Thank you, Siva
for
Rama Prasad
sharing your
ji.
experience.
Ah,
and
thank you,
knowledge.
sir.
Sir, you have spoken 3 hours continuously, and that shows your preparedness, and your presentation was excellent.
Sorry, sir. Thank you, sir. Thank you, sir.
Tomorrow also we'll join for another round, another three.
Yes, sir. Tomorrow, sir.
Thank you, sir.
Okay, sir. Okay, sir.
Thank you, sir. Thank you for sharing your experience
Ah, sir.
and learning and making the session interactive and insightful. Thank you very much.
Okay, sir. Thank you, sir. Now I am closing, sir.
Okay.
Okay, sir. Thank you.
Same link will be valid for tomorrow also, no?
Yes, sir.
Okay.